Going live in 5 seconds. We're live.
Okay. Good evening, everyone. I wish you all a very happy Ambedkar Jayanti. Thank you all for joining CEDE and LiveLaw on this special day. I'm Arsalan, and I'm a final year law student at Faculty of Law, Aligarh Muslim University. I'm joined by my colleague Kundan, and we both are CEDE fellows. We will be your hosts for today's event. We are honored that we are joined by Professor Ajantha Subramanian, who is a professor at City University of New York, who will be delivering the fourth Dr. Ambedkar Memorial Lecture today. Before we get to the lecture, we all are here for. Kundan and I would like to just take a bit of your time to talk about CEDE and our work. Baba Sahib once said, "My final words of advice to you are educate, agitate, and organize. Have faith in yourself. With justice on your side, I do not see how we can lose our battle. The battle to me is a matter of joy. The battle is in the fullest sense spiritual. There is nothing material or social in it. For ours is a battle not for wealth or for power. It is a battle for freedom. It is a battle of reclamation of human personality. CEDE stands for Community for Eradication of Discrimination in Education and Employment. We organize internships, jobs, and other opportunities for the students and graduates from marginalized communities, specifically Dalits, Adivasis, and other backward caste, nomadic, and denotified communities. Uh, uh, Nomadic and denotified communities. Transgender individuals, persons with disabilities, people from Northeast India, and other minorities. Since our inception in 2021, we have arranged close to 200 internships, over half of the interns being women, transgenders, or non-binary individuals. We have arranged 5 jobs at leading litigation offices in Delhi and legal research organizations. Through our recent collaboration with University of Windsor in Canada, we have been able to arrange fully funded overseas LLM admission for 2 graduates. Around 150 lawyers, law firms, legal organizations, judges, and academicians have graciously signed up to be a part of CEDE's network, through which we arrange the opportunity I just mentioned. We also organize and host workshops for developing the soft skill of students, such as CV building sessions and legal research sessions. CEDE's community of 1,000 students and graduates is over 500 members strong and only continues to grow every day. We hope to create a space where Bahujan students can feel safe and understood by providing increased access to educational and employment opportunities and skill development. We are able to do a small part in ensuring the birthright to education that Dr. Ambedkar spoke about. The topic of today's discussion is meritocracy and democracy, Indian reservation, and politics of caste. But before we start, I would request my colleague Kundan to introduce our guest. Kundan, over to you.
Thank you, Aslan. So, this side Kundan from CEDE, and I am pleased to and honored to introduce our guest for today, Professor Subramanian. Professor Subramanian is a historical anthropologist whose work addresses the historicity and political economy of caste. She is particularly interested in the incorporation of caste into projects of economy of caste. She is and transformation of capitalist transformation, and how these projects in turn have shaped the social relation of caste. Her work also considers caste as an instrument of classification and management that has been imagined and deployed in relation to other categorization of class, religion, and race. Her first book, Shorelines, Space and Riots in South India, chronicles the struggles for resource rights by Catholic fishers on India's southern coast, with a focus on how they have used spatial imaginaries and practice to constitute themselves as political subjects. Her second book, The Caste of Merit, Engineering Education in India, analyzed meritocracy as a terrain of caste struggle in India and its implication of democratic transformation. She is currently working on two projects. The first on the lead politics in a gold mining company town in South India, and the second on the transnationalization of caste in the US. Now I would like to request Professor Ajantha to take over this session.
Thank you so much. I'm deeply honored by this invitation to present the fourth Dr. B.R. Ambedkar Memorial Lecture. And I'd like to thank Disha, Anurag, Avinash, Arsalan, Kundan, and other CEDE fellows for this opportunity. And I'm really looking forward to the discussion following the lecture, which should be about 40 minutes long. So as Kundan said, the title of the lecture is Meritocracy and Democracy, Indian Reservations and the Politics of Caste. Within 1940s Indian modernization theory, caste was seen as antithetical to modern social life, with no place in a democratic polity. This was the promise of independence. At the stroke of the midnight hour, the equal citizen was to take the place of the unequal subject. At the same time, Indian statesmen acknowledged the persistence of social inequalities that needed redress. Dr. B.R. Ambedkar was the most strident in his rejection of presumptive equality. In November 1949, Ambedkar issued a warning to the Constituent Assembly. Quote, "On January 26, 1950, we will have equality in politics and inequality in social and economic life. We must remove this contradiction at the earliest moment, or else those who suffer from inequality will blow up the structure of political democracy, which this assembly has so laboriously built up," unquote. Ambedkar further elaborated on the two forms of persistent inequality. Quote, "On the social plane, we have in India a society based on the principle of graded inequality, which means elevation for some and degradation for others. On the economic plane, we have a society in which there are some who have immense wealth, as against many who live in abject poverty," unquote. There was general agreement in the assembly that the graded inequality of caste and the disparities of class demanded substantive redress. However, consensus broke down when it came to mechanisms of redress. Two key points of debate emerged at the time, which have been remarkably resilient. The first concerned the relative weighting of the fundamental right to equality and non-discrimination and the directive principle of redress for caste disabilities. The question of whether implementing forms of redress was itself discriminatory and a violation of the right to equality was and has remained hotly debated. Despite acknowledging that caste was an enduring form of structural inequality requiring state intervention, statesmen and lawmakers treated redress as a temporary departure from a liberal baseline of formal equality. The second point of debate was around the appropriate constitutional language of social differentiation, specifically whether caste should be accorded legal recognition. While caste classification was deemed necessary for scheduled castes suffering the stigma of untouchability, there was far less consensus on how to classify the intermediate castes. Even Kaka Kalelkar, chairman of the first Backward Classes Commission, established in 1953, advised the president to reject his own commission's recommendations because remedies on the basis of caste would not be in the interest of society and country. Instead, he proposed that the principle of caste be avoided altogether in favor of other indices. The central government agreed with Kalelkar's objection. A 1961 missive to regional state governments urged that, quote, "While the state governments have the discretion to choose their own criteria for defining backwardness, in the view of the government of India, it would be better to apply economic tests than to go by caste," unquote. We see in these concerns the palpable discomfort around acknowledging the very forms of lived inequality that rendered equal citizenship more aspirational than real. There was even a perverse twist of logic, whereby naming the problem itself became the problem. 3 Supreme Court judgments encapsulate this enduring tension between the endorsement of formal equality and the recognition and redress of substantive inequality. The 1951 Champakam Dorerajan case, the 1992 Indra Sawhney case, and the 2008 Ashok Kumar Thakur case. The first case challenged the constitutionality of the Madras Presidency's 1921 communal GO, reserving seats in regional medical and engineering colleges on the basis of caste and religion. The second case challenged the reservation of 27% of central government jobs for OBCs as recommended by the Mandal Commission. The third case challenged Mandal 2, which is the reservation of 27% of seats in all centrally funded educational institutions. Across these 3 cases, we see shifts and continuities in the legal landscape of reservations in India and in the framing of the debate. The courts moved definitively towards an embrace of reservations as a necessary mechanism of recompense and redistribution. At the same time, the focus on the appropriate criteria for determining backwardness left largely unaddressed the social bases of merit, quote unquote merit. Even as more and more ink was spilt in debating the caste versus class contours of historical disadvantage, the inheritance that underwrote merit slipped out of view. The effects of this asymmetry are evident in the popular politics around reservations, where the claim to merit on the part of upper castes is largely taken at face value. While there are many other cases on reservations, these 3 are particularly significant because each addressed a key site of upper caste capital accumulation. Regional government education in 1951, central government jobs in 1992, and central government education in 2008. The succession of cases also marks shifts in the geography of caste capital accumulation, from the regional to national state and from the public to the private sector. Across these cases, we also see the consistent stance of the Tamil Nadu government as a political outlier. In refusing to accord the individual citizen primacy over the caste collective, in opposing the coupling of caste with class criteria, and in exceeding the 50% ceiling on reservations, Tamil Nadu disregarded the liberal norm of formal equality. This has made the state a target of anti-reservations arguments. This is all the more so because Tamil Nadu's reservation system has prioritized the rights of OBCs. The steady growth in OBC quotas has redistributed positions in education and employment from upper to intermediate castes. At the same time, it has had a more limited impact on Dalit lives and even exacerbated status conflicts between intermediate castes and scheduled castes. In this sense, Tamil Nadu's reservation system has both transformed the hierarchies of caste and kept in place its work as a system of graded inequality. It has done both. For the remainder of my talk, I'll go through the 3 cases to offer some analysis of their aims and their effects, and the shifts in thinking across them, and then conclude with some final thoughts on caste and meritocracy. So let me start with the 1951 Champakam Dorerajan case. In 1950, 2 Tamil Brahmin petitioners, Champakam Dorerajan and R. Srinivasan, appealed to the High Court of Madras to protect their right to equality and non-discrimination. Both Dorerajan and Srinivasan argued that their fundamental rights, as guaranteed under Article 15.1 and Article 29.2 of the Constitution, had been violated by the communal GO, which mandated quotas in regional medical and engineering colleges. Dorerajan had not actually applied for admission in the Madras Medical College. However, she claimed that upon inquiry, she had come to know that as a Brahmin, she would not be admitted. Srinivasan, on the other hand, had applied for and been denied admission to the College of Engineering, Guindy. In his affidavit, he claimed that his marks in the school examination and the college admissions test would have secured him admission, quote, if selections had been made on merits alone, unquote. The timing of this case signaled the effort by Tamil Brahmins to take advantage of a new post-independence political configuration. In appealing to the constitution, Rajan and Srinivasan sought the support of the judiciary in reversing the redistributive measures of the Madras government and restoring their claim to regional education. In its judgment, the Madras High Court responded as they had hoped. It held that the communal GO constituted a violation of the fundamental rights of citizenship, and that Article 46, which directs the state to promote the educational and economic interests of, quote, the weaker sections of the people, unquote, could not in any way override or abridge these rights. The language of the judgment both acknowledged an obscured inherited caste capital as the basis of unequal citizenship. The judges argued that if selection had been made solely on the basis of quote-unquote merit, Brahmins would have obtained 249 seats out of the roughly 440 seats in government engineering colleges instead of the 77 they were allotted under the quota. Rather than proof of stark structural inequalities, the court treated this calculus as evidence of injustice against Brahmins. Consider this quote from the judgment. Quote, it may be that through the fortuitous operation of rule, which in itself is not discriminatory, a special advantage is enjoyed by some citizens belonging to a particular caste or community. If students belonging to a certain community or caste, by reason of their caste discipline, habits, and modes of life, satisfy the prescribed requirements in larger numbers than others, it is not permissible to shut them out on that score. It would be strange if, in this land of equality and liberty, a class of citizens should be constrained to wear the badge of inferiority because they have a greater aptitude for certain types of education than other classes, unquote. So here we see that how the special advantage enjoyed by Tamil Brahmins is naturalized as caste culture and made consistent with the fundamental rights of citizenship. Even as caste is acknowledged, it's remade from a system of graded inequality into community life. By contrast, it is the quota itself that is identified as a source of discrimination, denying Brahmins their quote-unquote greater aptitude for certain types of education and stigmatizing them as inferior. This remarkable statement laid the groundwork for subsequent arguments about upper caste rights as consistent with democratic principles and lower caste rights as a violation of these very principles. In 1951, the Supreme Court upheld the verdict of the Madras High Court. The unanimous verdict of both courts in striking down the communal GO met with a swift response from Ambedkar and Nehru. In June 1951, the first amendment to Article 15 of the Constitution was passed, stating that, quote, nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes, unquote. The First Amendment signaled a standoff between the judiciary and the executive on the relationship between fundamental rights and distributive justice. By the time of the next major reservation battle in the 1990s, however, the courts had shifted decisively towards a greater recognition of quotas as a necessary precondition for equality. The intervening years also witnessed the consolidation of Dravidinist rule in Tamil Nadu and the increasing divergence between regional and national stances on the caste question. Both these trends were evident in the second landmark judgment on reservations, which is the 1992 Indra Sawhney case. Between 1951 and 1991, the government of India set up two commissions to investigate the condition of the socially and educationally backward classes. As noted earlier, the 1953 Kalelkar Commission was ambivalent in its views and inconsequential in its effects. This was not the case for the second B.R. Mandal Commission set up in 1979. Not only were its recommendations implemented a decade later, Mandal became a hugely controversial household word in India. The Mandal Commission picked up where the Kalelkar Commission left off. It developed a more comprehensive social scientific methodology for determining social and educational backwardness, and on that basis recommended 27% reservations for OBCs in civil posts and services, falling under the central government, and in public sector enterprises and banks. When added to the existing 22.5% for scheduled castes and scheduled tribes, Mandal brought the total quota of reserved seats to 49.5%, just under the Supreme Court limit of 50%. There are four noteworthy points in the Mandal Commission's report. The first relates to the social life of caste. The report cautions against any hasty conclusion about the weakening of caste as the basis of social organization. While it acknowledged the increased pace of social mobility and the weakening of some, quote, traditional features of the caste system, unquote, it maintained that, quote, what caste had lost on the ritual front, it has more than gained on the political front, unquote. The report observes that the related shifts in the power equation between upper and lower castes had exacerbated social tensions that could be contained if, quote, the ruling upper castes handle the legitimate aspirations and demands of the historically suppressed and backward classes, unquote. The second key point relates to the definition of merit. In a chapter titled Social Justice, Merit, and Privilege, the report stated that, quote, merit in an elitist society is not something inherent, but is the consequence of environmental privileges enjoyed by the members of higher castes, unquote. Third, the report took on Kalelkar's opposition to caste classification by elaborating the relationship between caste and class. Referring to two prior judgments, it argued that, quote, caste is also a class of citizens. And if the class as a whole is socially and educationally backward, reservation can be made in the favor of such a caste, unquote. Finally, the report echoed previous judgments in emphasizing that OBC candidates recruited, quote, on the basis of merit in open competition, along with general candidates, shall not be adjusted against the quota of 27% reserved for them, unquote. In other words, Mandal mandated that the general category not become a de facto quota for upper castes. Significantly, the Mandal Commission targeted the very employment niche that had been insulated from regional political demands, that is, central government jobs. Unlike regional government jobs, which had been opened up through quotas, this upper tier of government employment was only mandated to implement the 22% quota for SCs and STs, which often remained unfilled. Moreover, because of their insulation from regional politics, central government education and employment had become synonymous with upper caste meritocracy. The Mandal Commission's report was discussed twice in both houses of parliament, in 1982 and 83, with no decisive outcome. It was only during the prime ministership of VP Singh that Mandal came into effect. Singh's statement in parliament in favor of implementing the commission's recommendations echoed the report's critique of merit. We talk about merit. What is the merit of the system itself? Singh queried. That the section, which is 52% of the population, gets 12.55% in government employment? That in class 1 employees of the government, it gets only 4.69%? I want to challenge first the merit of the system itself before we come to the question of merit. This was VP Singh's quote. This was his statement in favor of implementing Mandal. The uproar caused by the implementation of the Mandal Commission's recommendations on August 13th, 1990, was responsible for the defeat of the VP Singh government in the 1991 general elections. Even so, the successor government of P.V. Narasimha Rao largely accepted Mandal while underscoring its class criteria and adding a 10% quota for economically backward groups. The petitioners in the Indra Sawhney case issued several challenges to Mandal. First, they recycled older arguments from the 1951 Dorerajan case about reservations as a violation of equal rights. Second, they charged Mandal with making caste the sole criterion for eligibility. Finally, they argued against the role of the executive in expanding the scope of reservations. In making the last argument against executive action, Counsel K.K. Venugopal singled out Tamil Nadu as a constitutional violator, remarking sardonically that, quote, before every general election, a few communities are added to the list of backward classes, only with a view to winning them over to the ruling party, unquote. Tamil Nadu was a clear case, he argued, of fundamental rights falling prey to politics. The Sawhney judgment is exhaustive in its consideration of relevant cases both within and beyond India, most notably the United States. In the majority opinion, Justice Jeevan Reddy largely upheld the government orders implementing the Mandal recommendations. First, he underscored the admissibility of caste as a criterion in determining backwardness with a reminder of Ambedkar's original intent in using both the terms class and backward. Going by his words, Reddy argued, quote, it cannot be concluded that either class is antithetical to caste, or that a caste cannot be a class, or that a caste as such can never be taken as a backward class of citizens. The word class, in our opinion, is used in the sense of social class, and not in the sense it is understood in Marxist jargon, unquote. Second, Reddy ordered the exclusion of the quote-unquote creamy layer from among the OBCs. This, he emphasized, was a matter of, quote, proper and more appropriate identification of a class as a backward class. Of a caste as a backward class. If some of the members are far too advanced socially, which in the context necessarily means economically and may also mean educationally, the connecting thread between them and the remaining group snaps. They would be misfits in the class. After excluding them alone, would the class be a compact class? In fact, such exclusion benefits the truly backward, unquote. Third, Reddy struck down the 10% reservation for the poor as unconstitutional because there were no grounds for discriminating against those with economic means. Fourth, he limited the application of reservations to initial appointments and recommended that the total reservation of seats remain under 50% so as not to, quote, nullify the main rule of equality, unquote. Significantly, the strongest arguments in support of the Mandal Commission came from states with powerful lower caste movements, Bihar, Kerala, and Tamil Nadu. Tamil Nadu's political stance on reservations came through in two key arguments against the 1992 judgment. First, State Counsel Siva Subramanian argued forcefully against the creamy layer exclusion, contending that it was, quote, a mere ruse, a trick, to deprive the backward classes of the benefit of reservations, unquote. Second, he argued against the 50% ceiling as an arbitrary cap, especially in states like Tamil Nadu, where the enumerated backward caste population was over 80%. Against Counsel Venugopal's indictment of Tamil Nadu, Subramanian heralded the state as a model with its long history of reservations dating back to 1921 and steady growth in the quota to the current level of 69%. Before we move to this third judgment in 2008, let us take a moment to appreciate the significance of the judiciary's shift in perspective from 1951 to 1992. In 1951, the justices of the Supreme Court viewed reservations as a political corruption of the principle of formal equality. By 1992, their concern was no longer about upholding liberal principle, but about finding the correct balance of merit and reservations as the only means to substantive equality. Moreover, the form of substantive equality was now advanced in the language of technical measures. From the upholders of a liberal legalist vision, pitted against the democratic calculations of the executive, the judges had themselves assumed the role of technocrats, working to engineer the perfect balance of outcomes. Significantly, upper caste self-definition had also shifted from using only the language of formal equality to increasingly relying on the very terms of reservations policy. Even as upper caste argued vociferously against reservations, they defined themselves more and more as members of the general category. Reservations has provided them with a new language of hierarchical classification that has become the basis not only for caste distinction, but increasingly for caste consolidation. The third consequential judgment on reservations was in response to what came to be known as Mandal 2. This involved the second part of the Mandal Commission's recommendations, which was 27% reservations for OBCs in centrally funded higher educational institutions. In 2005, the Government of India passed the 93rd Amendment to the Constitution, adding a fifth clause to Article 15 that allowed the state to make special provisions for socially and educationally backward classes in all educational institutions, whether public or private, state-aided or non-state-aided. This was followed in 2006 with the with the Central Education Institutions Reservation in Admission Act, which brought all central government educational institutions under the umbrella of the 27% OBC reservation. Together, the 93rd Amendment and the 2006 Act opened the door to the implementation of Mandal 2 within the most elite echelon of public higher education. Mandal 1 and Mandal 2 were implemented at very different moments. Unlike in 1992, when central government jobs were still highly coveted, Mandal 2 came well after the advent of economic liberalization and the explosion in private sector employment. It sought to democratize admission to the top echelon of public higher educational institutions, which were proven stepping stones to private sector opportunities. The challenges to Mandal 2 came very quickly. Altogether, there were 12 cases filed on various grounds. Most reprised older arguments about the fundamental right to equality and the need to exclude the creamy layer. To these were added some new arguments. One, that while SC/ST reservations were justified, the economic advancement of OBCs and the severing of the caste occupation nexus, as they called it, made them ineligible for reservations. Two, that the expansion of reservations to include OBCs was excessive and had resulted in quote unquote reverse discrimination against the non-reserved. Three, that the 27% OBC quota was quote not a genuine social engineering measure, but vote bank politics, unquote. Four, that the extension of reservations to government-aided private educational institutions was an unconstitutional effort to nationalize these institutions. And five, that without a specified time limit for reservations, they were by definition unconstitutional. So in these challenges, we see the sense of threat posed to upper castes by OBCs in particular. Unlike scheduled castes and scheduled tribes, OBCs were perceived as real competitors who had the potential to disrupt upper caste entitlements. Indeed, we even see a rhetorical endorsement. This was not a real endorsement, a rhetorical endorsement of the SC/ST quota as a counterpoint to the OBC quota. But there were also those who felt that the government orders implementing Mandal 2 had compromised on social justice by incorporating class criteria. These petitioners maintained that caste as an autonomous and enduring system of stratification should be the sole criterion. Once again, Tamil Nadu represented this position most clearly. The Council for the Patali Makkal Katchi, a Tamil political party representing OBCs, argued that it was only the creamy layer who could avail of such opportunities. Quote, if the best from the lower caste are deprived of these facilities and opportunities in the name of creamy layer, the council stated, it would be counterproductive and frustrate the very object of reservation, namely to achieve equality in status, facilities, and opportunities, unquote. Most of the challenges were shot down by the court. First, the justices maintained that a constitutional amendment, quote, which moderately abridges or alters the equality principle, unquote, cannot be said to violate the basic structure of the Constitution. In striking contrast to the 1951 judgment, they argued for the crucial role of directive principles in a democracy. Quote, it is the directive principles which nourish the roots of our democracy, provide strength and vigor to it, and attempt to make it a real participatory democracy. The dynamic provisions of the directive principles fertilize the static provisions of the fundamental rights. The object of the fundamental rights is to protect individual liberty. But can individual liberty be considered in isolation from the socioeconomic structure in which it is to operate? There is a real connection between individual liberty and the shape and form of the social and economic structure of the society, unquote. Second, they affirmed the constitutionality of quotas and pointed out yet again that, quote, the equality of citizens is the basic feature of the Indian Constitution, but by equality is meant not formal or technical equality, but real and substantive equality, unquote. Third, they referenced the 1992 Indra Sawhney judgment in reiterating that while caste was distinct from class, the correlation between the two made caste a legitimate basis for determining social and educational backwardness, so long as it was not the sole criterion. In this, they also went against the Patali Makkal Kachi's objection to the creamy layer exclusion, while cautioning against applying, quote, a strict income restriction, unquote, because this might mean that those who are left in the particular caste may not be able to have a sufficient number of candidates for getting admission in the central institutions, unquote. To avoid this outcome, the justices authorized the central and state governments to, quote, make a relaxation to some extent so that sufficient number of candidates may be available for the purpose of filling up the 27% reservation, unquote. The sequence of Supreme Court judgments from the 1950s through the 2000s illuminate changes in judicial opinion on reservations. From a more categorical stand in favor of formal equality, the court moved towards an embrace of compensatory measures to bridge the gap between formal and substantive equality. Nominally, the redress of caste inequality was an ambition shared by the judiciary and by lower caste movements. However, they diverged when it came to the perception of upper caste. For the judiciary, the upper caste subject remained the ideal citizen, defined more by individual merit than by caste history. Even as the courts ratified the redress of caste disadvantage, they were unable and unwilling to fully acknowledge and address caste privilege. In all the wrangling over the precise parameters and criteria of backwardness, the assumptions behind what constituted merit were left largely unquestioned. Even as the quotas for OBCs, SCs, and STs expanded, and reservations became an accepted measure of redistributive justice, assumptions about the innate meritoriousness of the non-reserved stayed mostly in place. It was only the reserved who came to be marked by caste history and identity, while the non-reserved stood in simply for casteless individual excellence. This is evident even in those instances where judicial statements directly addressed the question of merit. Take Justice Jeevan Reddy's statement in 1992 in response to the concern that quota candidates would necessarily mean a decline in the efficiency of administration. Reddy agreed that, quote, the very idea of reservation implies selection of a less meritorious person, unquote, but went on to insist that, quote, at the same time we recognize that this much cost has to be paid if the constitutional promise of social justice is to be redeemed, unquote. Reddy further argued for a developmental approach to merit. Quote, Given an opportunity, members of these classes are bound to overcome their initial disadvantages and would compete with, and may in some cases excel above, open competition candidates. It's undeniable that nature has endowed merit upon members of backward classes as much as it has endowed upon members of other classes, and that what is required is an opportunity to prove it. It may not therefore be said that reservations are anti-merit. Merit there is, even among the reserved candidates, and the small difference that may be allowed at the stage of initial recruitment is bound to disappear in course of time. These members too will compete with and improve their efficiency along with others, unquote. While Reddy insisted that the potential merit of the reserved only needed appropriate opportunities for expression, he stopped short of interrogating the social backgrounds of the unreserved. Ultimately, his developmental logic about merit as the unfolding of natural ability led him to limit reservations to positions that were less prestigious. For higher levels of the state's educational, service, and administrative institutions, he stated, quote, merit alone counts, and provision for reservation would not be advisable, unquote. These limits of judicial action maintained an upper caste meritocratic norm. Even as the directive principles were made actionable and arguments about formal equality challenged, the role of caste history on the merit side of the equation remained curiously invisible. This was especially the case in the educational domain, with its correlation between the general category and merit-based admissions. The semantic equivalence between the general and the meritorious reinforced the idea that those who fall within the general category do so not on the basis of accumulated caste privilege, but by dint of their own merit. This categorical distinction between the meritorious or casteless and the reserved or caste-based has profoundly shaped the debate around educational equality in India. It has allowed those who fall within the general category to argue, to invoke what sociologist Pierre Bourdieu calls an, quote, imaginary universe of perfect competition or perfect equality of opportunity, a world without inertia, without accumulation, without heredity or acquired properties. That's the quote from Bourdieu. To argue that it is the system of reservations and not the inheritances of caste that undermines the modern Republican ideal of equal citizenship. Sociologist Satish Deshpande has argued that the unmarking of upper castes was built in the logic of constitutionalism from the very beginning. The new constitution, he maintains, quote, constrained the victims of caste to demand justice as a caste-based as a caste-marked exception, while its beneficiaries were empowered to demand the perpetuation of their advantages as a casteless norm, unquote. Deshpande dates this back to the 1951 verdict, which offered upper castes a form of agency, quote, based on the universal normative position of castelessness. Constitutionally and legally, caste was henceforth to be recognized only as a source of disadvantage or vulnerability, not as a source of privilege or advantage, unquote. For upper caste, Deshpande concludes, quote, caste qua caste has already yielded all that it can and represents a ladder that can now be safely kicked away. Having encashed its traditional caste capital and converted it into modern forms of capital like property, higher educational credentials, and strongholds in lucrative professions, this section believes itself to be casteless today, unquote. Looking back at the three consequential judgments on reservations, Deshpande's argument holds, but only partly. It's true that in the logic of the legal judgments, the imagined future of castelessness was transposed onto the general category. Judicial intervention reinforced the perception of upper castes as casteless moderns whose merit was attributed to accumulated talent, not privilege. However, we also see something else in the 1951 judgment, and this is the marking of caste as culture, as natural aptitude, and as the very basis of merit. Contrary to Deshpande's argument, upper caste did not just come to see themselves as casteless. Rather, there was a tension between caste marking and unmarking in their claims to merit. We see this first with Tamil Brahmins. Rather than disavow caste, Tamil Brahmins have made caste belonging the very basis of merit, while at the same time claiming their commitment to democratic principles. In Tamil Brahmin claims to merit, we see that castelessness is actually an aspect of upper caste self-definition. With the expansion in lower caste rights politics across India from the 1990s, such identitarian claims to merit has spread beyond Tamil Nadu and have become much more overt. Just as proponents of reservations have taken to the streets and the ballot box to make their demands known, so too have upper caste engaged in collective action as the non-reserved to express their opposition. More recently, some upper caste groups have demanded not the abrogation of reservations, but its further expansion to include them. We see this, for instance, in the July 2015 claim for quotas by Gujarati Patidars. Following the Patidar agitation in Gujarat, numerous other upper caste groups also began to agitate for inclusion in the reserved category. The Marathas in Maharashtra, the Jats of Haryana, and the Brahmins of Kerala. The most recent twist in reservations is the 10% quota for economically weaker sections. By setting aside seats for so-called economically weaker groups to the exclusion of all of those already covered by other quotas, and by setting the income ceiling for eligibility at 8 lakhs, the EWS category operates as a quota for middle-class upper caste. Such demands for inclusion or reclassification within the reserved category rest on a key assumption, that the quota as an entitlement to education and employment can be distinguished from the longer historical experience of social and economic marginalization and stigmatization. Such upper caste demands for quotas only target the more recent history of redistribution, which they argue have disenfranchised them of their rightful due. What we're witnessing is the appropriation of the language of injustice and redress by groups who have been the historical beneficiaries of caste. Much like the 1951 judgment by the Madras High Court, such claims transform reservations from efforts at redressing inequality to its very source. So let me now conclude with a brief recap of the argument and just 2 questions. Reservations explicitly named caste as a factor in educational and employment outcomes. In setting aside a percentage of seats for lower caste groups, reservations policy sought to correct for historically sedimented disadvantages. At the same time, by marking only its beneficiaries as caste subjects, reservations policy reproduced the status of upper caste as meritocratic and casteless. Initially, when only SC/ST quotas were implemented, upper caste expressed the claim to meritocracy in universalistic terms that did not require an explicit defense of caste identity. However, this changed with the steady expansion of quotas, alongside the expansion of lower caste rights politics. With the implementation of Mandal 1 and 2, upper caste claims to meritocracy were no longer simply universalistic. They became far more defensive and explicitly identitarian. To put it differently, upper caste claims moved between caste unmarking and caste marking. On the one hand, they claimed to be universal subjects who had transcended caste. On the other, they claimed that they were uniquely meritorious because of their caste. But this was caste defined in cultural terms that skirted its power as a source of inherited and acquired capital. The culturalization of caste has allowed merit to be seen as a natural feature of upper casteness, something that is innate to these groups. This tactic of securing entitlements in the name of both merit and caste leaves little room for challenging inequalities. It erases the histories of violence and discrimination that have allowed for the reproduction of caste privilege and disadvantage. So I want to leave you with 2 questions. How much space is there in the law to directly challenge the caste underpinnings of merit? And what other tools are necessary to denaturalize caste as culture by foregrounding the histories of caste and the histories of capital accumulation? Thank you.
Thank you, Professor, for a lecture. Now I will open the forum for question and answer round. I will ask our audience to please write down your question in the chat box of the LiveLaw YouTube channel, and from there we will take up the question. So the audience can write down your question in the live chat. Professor, we have a question that what do you think of the EWS quota in the overall context of measures intended to remedy historical wrongs?
Yeah, I mean, as I said at the end of the talk, you know, the EWS quota, first, it violates the constitutional principle that class alone cannot be the basis, right, of redistributive measures, right? I mean, this is a principle that has been upheld all the way through until very recently with the implementation of this quota. The second thing is that the way it treats class is itself hugely objectionable, right? So this is a quota that explicitly excludes all groups that are already covered by pre-existing quotas. So in effect, it is a quota for upper caste, right? It is a quota for upper caste. And the income ceiling in the quota makes it a quota, the income ceiling in the category makes it a quota not just for upper caste, but for relatively affluent upper caste, right? 8 lakhs is not a low ceiling. And so in all of these ways, it is intended as a measure to provide a quota for groups that don't really deserve redistributive justice, right? These are not groups that have experienced historical injustices, right? So I think in that sense, it's a real perversion of the principle of reservations, right? The principle of reservations, which is to identify groups who have experienced disadvantage historically, right? For whom disadvantage is an inherited predicament. It's an inherited predicament that cannot be corrected without such interventions, right? The EWS quota identifies a group that doesn't fulfill these criteria by any measure. And I'll say one more thing, which is that, you know, in all of these arguments against reservations, the trope of the poor Brahmin has become a sort of a consistent trope, right? So when people talk about disadvantages, when people talk about reservations as an injustice, you know, very often this figure of the talented poor Brahmin, right, who experiences the quota as reverse discrimination, right? This sort of trope of the poor Brahmin, you see continuously being recycled across these anti-reservations arguments. And sure enough, the EWS category is for that very group, right? It's for this mythical poor Brahmin who has been systematically discriminated against by the succession of reservations quotas, right? So I think that's what you're seeing in the EWS quota, both a perversion of the principle of reservations and a quota that takes this lip service that has been paid to the poor Brahmin, right, and makes it a reality, right?
Yes. Now, ma'am, we have a second question that Kundan will ask. Kundan, you want to ask a question?
Yes, yes. Thank you, Aslan. So, ma'am, I have a question on particularly on reservation in private sector jobs. So, there was a paper published in 2007, I guess, by Professor Sukhdev and Paul, in which they have like on the basis of collected data regarding applications in private sector jobs, and they have like given this proposition that if a person who is belonging from Dalit community and he has that tag in his name, like some identified surname and something like that. And if he is applying for a job in a private sector or private market, then there is less chance to get that job. And if same application go with the title with the upper caste surname, then that person will be more likely to get that job. So my question is that in this context, and now Dalit movement and Dalit right activists now asking for reservation in private sector, and this same demand was there in UPA first government in 2005 and come in public. So I would like to know like what will be your comment on this situation of demands of reservation in private sector in this context, like present context.
Yeah. No, I mean, I'm completely in favor of it. Look, the private sector is the most rapidly expanding sector of the Indian economy, right? And this has happened alongside the expansion of reservations. But what that has meant is that the impact of reservations is less and less significant, right? Because of the number of jobs that have shifted from the public to the private sector, right? So, you know, given that the private sector is the most rapidly expanding sector, the implications of this is that the private sector has become the site for the retrenchment of caste privilege, right? That's what has happened. So you've seen the flight of upper caste from the public to the private sector, where they are once again able to accumulate capital in the way that they did in the public sector, right? So they've abandoned the public sector for the private sector. And I think that you're seeing this also in education, right? You're seeing it both in employment and in education. I mean, the boom in private sector education, right, where the most coveted institutions now of higher education are becoming private sector schools and colleges and universities. There are parallel trends in the employment sector and the education sector, where there's a sort of flight of upper caste into the private sector, right? And what's happened is that flight of upper caste into the private sector has also been paralleled by the devaluation, right, of public sector education and employment, the defunding of public sector education and employment, right? So just when historically disadvantaged groups have managed to secure some measure of inclusion into spaces of education and employment that were previously inaccessible to them, just when that has happened, you are seeing basically a sort of shrinking of those spaces, right? A shrinking of those spaces and the expansion of the private sector. So I am all in favor of private sector reservations. In fact, I think it's absolutely necessary, right? And I think the other thing to say about that, the argument that, this is the market does not discriminate, right? I mean, this is one of the arguments that's made against private sector reservations. The market does not discriminate, which is total rubbish, right? There are plenty of studies that show that, you know, whether you're talking about caste markers or racial markers, right, that people who bear these markers are systematically discriminated against in private sector education and employment, right? So you mentioned the study in India, but there are parallel studies in the United States, right, that show that, you know, that do these sort of tests where you submit two applications, one with a quote unquote racialized name, one with a non-racialized name, and the outcomes are very patterned. They're very patterned, right? You see that the non-racialized name gets opportunities that the other person does not. And of course, the India-based studies prove the same kinds of outcomes when it comes to caste marked or uncaste marked names, right? So I think it's absolutely necessary. I think if the point is redistributive justice, reservations cannot be limited to the public sector. They would not have the impact that is necessary, right, for real redistribution.
Okay, thank you, Professor. Actually, we have some more questions in the chat box from our audience. If you will allow, we can ask one or more questions.
Yeah, I can. I have about 5 minutes left, so I can definitely take at least one. Yeah, maybe you
Okay.
can just read me all of the questions, and I'll try to address them together.
Okay. So Tanvi has asked, "Hi, Professor. How to interpret organization/institution definition of merit in recruitment advertisement/policy?" And Ruchika has asked, "What do you think about dominant castes taking up reservation when the backward classes haven't fully benefited?" And last question is, what should be the role of fully Ambedkarite organizations and other progressive organizations in raising the injustice occurring due to non-implementation of reservation? So these three questions, if you want to go ahead with this.
Yeah. Okay. So, look, I think what is really important is to continuously insist on the caste basis of merit. Okay, I think this is a really important political argument to make, right? That the non-reserved is itself a caste category, right? That is really important. And why is that important? It's important because we need to recognize that merit is what we call merit, right? The ability to compete and secure coveted forms of employment and education, that ability is the byproduct of historical privileges, right? That have been accrued on the basis of caste. So that is something that we have to continuously keep in view, right? We have to continuously insist that merit is not about innate talent. It's not about individual ability. It is it's a caste-based set of what? Not practices, but it's a caste-based set of just abilities, right? These are not abilities that come out of nowhere. They come out of histories of inequality, right? So I think that's something that has to be kept in view all the time, right? We have to continuously insist that merit is not some universal principle, right? That some people just happen to embody, right? Some groups embody merit because they have benefited. They're beneficiaries of caste. The meritorious are beneficiaries of caste. We have to continuously say this. They are beneficiaries of caste. In terms of, I think that the second and the third question are in some ways parts of the same question. I think that the claim to quotas on the by upper caste, again, I think it's a perversion of the principle of reservations, right? Reservations should be limited to groups that have inherited forms of disadvantage, okay? And who have experienced these disadvantages over the long term, right? These are sort of it's an intergenerational transfer of disadvantage. That is what is being addressed. That is what is being corrected for with reservations. That historical predicament does not apply to upper caste, right? So I don't think that upper caste quotas, I don't think they're valid, right? I don't think they're valid. I think that they are a perversion of that principle. The non-implementation of reservations, yes, I think that it's not enough to have quotas on paper, right? They have to actually become real. And the only way to do that is to put pressure on institutions to ensure that they implement the law, right? I mean, these are institutions that are falling foul of the law. The non-implementation of quotas is an abrogation of the law. So that needs to be addressed. And I think that the arguments that there are no qualified candidates, that has to be tackled head on, right? That has to be tackled head on. Because that itself, the idea that there are no qualified candidates, that itself is an expression of discrimination, right? That itself is a form of caste discrimination. So what they're doing is that they're using caste discrimination to undercut a mechanism that has been implemented in order to address caste discrimination. So it's a kind of it's a very sort of perverse way of using caste discrimination to undercut the very policy of reservations. So I think that there has to be pressure put on these institutions. Unfortunately, there's very little institutional or political will to make that happen. So I think in the absence of institutional will, in the absence of political will, it's social movements, it's Ambedkarite, Periyarite, Phuleite. These are the groups that have to sort of fill the breach, right? I mean, you have to sort of demand that these policies are not just on paper, right? That the law is implemented, and there has to somehow be mechanisms for penalizing institutions that don't implement these policies, right? They're violating the law. Yeah.
Okay. Thank you so much, Professor. We will be ending this event. On behalf of CEDE, I would like to extend my heartfelt gratitude to our guest, Professor Subramanian. Thank you so much for accepting our invitation and taking the time out for this event. We would also like to thank our in-panel network. CEDE is supported by several lawyers, law firms, and professors whose commitment and collective effort makes us stronger, and we are able to do what we are doing. We are also thankful to our patrons, donors, and many unnamed contributors from crowdsourcing who helped us fund our initiative. Your contribution makes all the difference. Apart from running an NGO that requires operational logistical expenses, we also offer a scholarship to the students. So so in the last cohort, we offered scholarship to students from rural areas so that they could make it to the city for the physical internship. That is the work we as an organization at CEDE do. So we are very grateful and thank you again, Professor Subramanian, for this enlightening lecture. Finally, I would also like to thank LiveLaw for agreeing to host the event on their YouTube channel and for live streaming this without even a glitch. I also want to thank every participant for being there and making this event successful and asking question. Thank you, everyone. Thank you.
Thank you so much, and continue the amazing work that you're doing.
Thank you. Yes.
It's invaluable work. Congratulations.
Thank you so much.
Thank you so much, ma'am.